3, 2, 1.
So guys, this is an episode whereby Scott talks law, and welcome to another episode whereby Scott talks law. So in this episode, we will be talking about privilege. So privilege, this refers to the right which the law confers on a particular party not to adduce evidence on particular issues that directly affect that party. So there are matters that, even though they relate to the facts in issue, the court may exclude those facts from being adduced in court, or those matters from being adduced in court on the grounds of public policy and privilege. So privilege refers to that right that a party has not to adduce evidence on particular issue that directly affect that party. If that evidence is to affect that party directly, then the court won't allow those evidence from being adduced. So there are 4 instances where privilege can be raised. The first instance is the privilege against self-incrimination. The second one is the privilege against the legal professional privilege. The third privilege is the spousal privilege, and the fourth privilege is the prejudicial privilege. So under those 4 instances, the court won't allow production of evidence or testimonies on those matters where privilege has been raised. So that is just the introduction to privilege. In the next episode, we'll be talking widely on the public policy and privilege. Just stay in touch for more episodes. So the second form of privilege is the spousal privilege. And this form of privilege protects the confidentiality of communication made within the marriage and prevents one spouse from falsely testifying against the other in matters relating to the confidentiality of the marriage. So the court shall not compel one spouse to testify against the other in issues or matters relating to the confidentiality of the marriage without the consent of the person who made those statements, or the spouse who made those statements. So the spouse of an accused person is not a competent witness for the prosecuting side and shall not be compelled to produce or testify against the other spouse. So Section 130 provides for marriage here to include polygamous marriage, not only monogamous but also polygamous marriages. And in the case of Ramping versus DPP, in cases whereby this information was intercepted by a third party, now not those spouses, a third party. If this is Jane and Solomon, and a third party, another person apart from Jane and Solomon, intercepts those information, then that information can be allowed because the privilege here is on the spouses but not the information. So if this information was intercepted by the third party, then that information will be allowed. It's just like an exemption to this privilege. So this privilege extends even after the marriage has dissolved. Even after the divorce or death of the spouses, the privilege is still there. So that is about the spousal privilege. So self-incriminatory privilege. So this type of privilege protects an accused person from being asked to answer or being compelled to produce documents on evidence that will self-incriminate him in any other proceedings other than the present charge. So there is that protection that an accused person is granted not to produce evidence on issues that will self-incriminate him. So Section 128, and as it was held in the case of Bland versus Parkland Hotel, an accused person is not supposed to give answers or testimonies to evidence that will self-incriminate him in any other charge other than the perjury or the present charge. So an accused person is supposed to give answers or testimonies to matters relating to facts in issue. But in cases whereby this person does not give answers to facts in issue, matters relating to facts in issue, but gives self-incriminating answers, then those answers cannot be used against him in other criminal proceedings other than the present charge. So Section 138 provides that if an accused person wants to give self-incriminatory answers, then he must inform the one who is seeking those self-incriminatory answers in form of documentation. He can document to that person to inform him that he is going to give self-incriminatory answers. So he's supposed to enter into a document with that person seeking the production of self-incriminatory answers. So in the case of Elman versus Republic, it was held that it is a constitutional right that for a person not to give self-incriminatory answers. So it's a constitutional right not to give answers that are self-incriminatory. So the waiver of privilege, this is whereby an accused person decides to become a witness. So if an accused person decides to become a witness, then we say he has waived the privilege against self-incrimination. So that is all you need to know about self-incriminatory privilege. So the second form of privilege is the spousal privilege. And this form of privilege protects the confidentiality of communication made within the marriage and prevents one spouse from falsely testifying against the other in matters relating to the confidentiality of the marriage. So the court shall not compel one spouse to testify against the other in issues or matters relating to the confidentiality of the marriage without the consent of the person who made those statements, or the spouse who made those statements. So the spouse of an accused person is not a competent witness for the prosecuting side and shall not be compelled to produce or testify against the other spouse. So Section 130 provides for marriage here to include polygamous marriage, not only monogamous, but also polygamous marriages. And in the case of Ramping versus DPP, in cases whereby this information was intercepted by a third party, now not those spouses, a third party. If this is Jane and Solomon, and a third party, another person apart from Jane and Solomon, intercepts those information, then that information can be allowed because the privilege here is on the spouses but not the information. So if this information was intercepted by the third party, then that information will be allowed. It's just like an exemption to this privilege. So this privilege extends even after the marriage has dissolved. Even after the divorce or death of the spouses, the privilege is still there. So that is about the spousal privilege. So another form of privilege is the legal professional privilege. And this form of privilege exists between the client and the advocate. And none of the two shall be compelled to provide information about the communication made between them. So Article 134 sub-Article 1 protects either the client or the advocate from giving or providing information about the communication made between them in that course of giving that legal advice. So they are immune from giving or testifying of the information during the course of giving that legal advice. So in the case of Grant versus Downs, this form of privilege assists in enhancing the administration of justice. That legal professional privilege, it assists in enhancing the administration of justice in the giving of legal advice and facilitating the representation of a client by an advocate. So Article 1. So the case of Omari, son of Hassan versus the Republic, the information that the client has refused to comply to the advice given by the advocate was declared to be a breach of legal professional privilege. So it wasn't allowed by that court. So there are two categories of legal professional privilege. The first one is the litigation privilege and the second one is the legal advice privilege. And the litigation privilege, this arises after the commencement of the litigation. So this protects the confidentiality of information made after the commencement of the litigation. So a client cannot communicate that information to maybe a third counsel. So that confidentiality is protected after the litigation has commenced. So the second one is the legal advice privilege, and this includes all communication, oral or documentary, made in the course of giving that legal advice. So in the case of Brown versus Foster, a client can refuse to divulge the information given by the advocate, and the advocate can also refuse to divulge the advice or communication given by the client. So both of them can refuse to divulge. So this privilege is only exempted, or it does not exist, whereby there is a criminal activity going on in where there is an anticipation of any crime or criminal activity. Another form of privilege is the prejudicial privilege, and this form of privilege arises where the parties to a suit makes statements without prejudice in the attempt of solving or coming up with a solution to a dispute. So prejudicial statements cannot be produced or said without the consent of both parties who made those statements. So any statement or communication made in an attempt of solving or coming up with a solution to a dispute cannot be allowed. There is that privilege that has been allowed. It's called the prejudicial privilege, and it was held in the case of Waldridge versus Canisa. The prejudicial privilege. Communication made in an attempt of coming up with a solution to a dispute cannot be allowed. It has been given as a privilege, and that is the prejudice.